Good evening, everyone. Welcome to the YouTube channel of RankersBuzz. Today, we are again here to discuss a new landmark judgment for the year 2022-23. So, in this series, today we will discuss about a very important judgment being pronounced in the 2022. And this particular case that we are going to discuss today is related to a very infamous terrorist, that is the Abu Salem. So this particular judgment is related to the terrorist Abu Salem, who has been indulged into different kind of terrorist activities, including the Bombay Blast case of 1993, Bombay Blast case 1993, and he has also been involved in the extortions, multiple extortions from the Bollywood actresses and actors, and he has also been involved in multiple murder cases, multiple extortion, trespass, and also he has been indulged into transporting the weapons from Gujarat to Bombay during the 1993 blast in the Mumbai. So there are multiple cases against him. He has been indulged into multiple terrorist activities, and later on he flew to the Portugal, and he was arrested way back in 2001 in the Portugal Lisbon. He was arrested in Lisbon of Portugal for the offense of having a fake passport, and he used to show that he belongs to the state of Pakistan, and he had a passport of Pakistan that was a fake passport, and because of that, he was arrested in the Lisbon, Portugal. So today we will discuss about this judgment, and we will also know that why it is important to discuss this case at this point of time when he's already been arrested in the 2001. So let's come to this particular case that has been decided by the Honorable Supreme Court. So if I talk about the name of this particular case, then it is Abu Salem versus State of Maharashtra, 2022. And this is a appeal case. An appeal has been filed on behalf of the Abu Salem. Appeal has been filed, and in that only the Supreme Court has decided certain things. So let's see. This case has been heard by the two-judge bench, the division bench, and that is the Justice Sanjay Kishan Kaul, Justice Sanjay Kaul, and Justice Sudresh. Justice Sudresh has heard this particular case. So first we'll see that what are the different facts of this case, what has been presented before the court, and what this court has decided, or on what facts the court needs to decide. So let's look at the facts of this case. So when we talk about the facts, it says, firstly, Abu Salem, as I already introduced you, वैसे तो he does not need any kind of introduction because everybody know about him, the kind of history he has with respect to the serious crimes. And he has been part of the, crime syndicate. He has been part of the crime syndicate, which was operating in the Mumbai and other parts of India. And he has also been tried under Section 302, 307, that is murder, attempt to murder, then 452, then 506, that is trespass, then He has also been, charged under the TADA. TADA, we know TADA is related to the Terrorist Activities Act. So it is Terrorist and Disruptive Activities Prevention Act 1987, Terrorist and Disruptive Activities Prevention Act 1987. So he has been charged with these many sections of the IPC. These are the sections from the IPC related to murder, attempt to murder, intimidation, and the trespass. So this is related to the IPC, very serious, offenses under IPC. Then he has also been charged under the TADA, that is Terrorist and Disruptive Activities Act 1987. So what happened in this case? He was involved. It is said that he was involved in the Mumbai blast case of 1993. 1993, Abu Salem was found. Abu Salem was found involved in blast. Whatever blast happened in the Mumbai, he was involved in that. And in that blast, a lot of loss of life has taken place in the Mumbai, and a lot of losses to the property as well. He has also been alleged in the 1993 itself. He was, involved in smuggling AK-47, sorry, AK-56 rifles, hand grenades, as well as the magazines of bullets from Gujarat to Mumbai. He transported these many things for this attack from the Gujarat to the Mumbai, and he was into this plan. He was, into the plan. He was, whatever plan was made, he was part of that. And that is also very actively, he was one of the masterminds of that particular incident, which happened in the 1993. He was taking all these weapons in a Maruti car, in a Maruti van. He was taking all these things, which was specially crafted to keep these things from, Gujarat to Mumbai for the blast. And in order to evade from all these things, which he had done, in sabhi se bachne ke liye, he flew from the Mumbai. He left Mumbai. Ki bhai, now I don't want any kind of, imprisonment or so. So he left Mumbai and illegally entered the Portugal. Left Mumbai and went to Portugal. He landed in Portugal under an assumed identity of a Pakistani passport, with a Pakistani passport. And it also gives an indication, that there was active participation of the handlers from the Pakistan. So we can say that, it was handled by the Pakistan, and in this blast, Pakistani, handlers were involved, and he was part of that, because he was also using the Pakistani passport to travel from Mumbai to the Portuguese. And later on, because of having this fake passport, the Pakistani passport, which was a fake passport, he was arrested. He was further arrested by the Portugal police. Portugal police arrested this person, that is the Abu Salem, and Salem was sentenced the jail from 18 September 2002 to 12th of October 2005. And later on, he is to be released from the Portugal jail. He was about to be, you know, released from there. But in between, the Indian agencies applied for the extradition to get this person back to India because he is involved into the blast case. He has been involved in the terrorist activities. That's why the Indian agencies requested to Portugal to hand over this person to the Indian agencies. And that's why it was handed over to the government of India after his extradition. And the Indian government, the government of India, the government of India promised promised the Portugal government because they have also asked the promise of India that he must be released after imprisonment of 25 years. He cannot be kept under the imprisonment more than 25 years. बोला गया कि भी इसको जो है 25 साल बाद आपको कम से कम छोड़ना पड़ेगा, आप इसको लाइफ टाइम जो है जेल में नहीं रख सकते हैं. And on that condition only he was being given to the Indian agencies. So now this promise was already being made by the government of India to the Portugal government. Promise was made that he will be released. He will be released after 25 years. So you can say that he cannot be into jail after completing the 25 years tenure. And that's why now it's been around 5 to 6 years now when he is going to be released. So that's why this appeal has been filed before the Honorable Supreme Court. And he has asked a few things. He said that I have already spent about 3-4 years. He says that I have already been into jail for about 4 years in Portugal. So those 4 years must also be calculated when it comes to the 25 years. So basic idea is that I must be released within 21 years calculated from the 2005. Sorry, 2005 when I was back in India. So it must be calculated from there, and that is of 21 years. This has been requested by this person. Now, why he need to be released after completing 25 years of sentence? The question has been raised, or one question may come to our mind that why he must be released, why he must be released after completion of 25 years of imprisonment. Because we know that he is a terrorist, he has done a lot of crimes. So why he should be released? What are the reasons for that he must be released? So the Supreme Court says that for the answer of this question, it has been said by the Honorable Supreme Court that the affidavit of the Union of India through the Home Ministry or the Home Secretary is very much clear. If we talk about the affidavit filed by Union of India is very much clear, that at least to the effect that they will abide by the assurance given to the government of the Portugal. Now, affidavit में ये लिखा है that the Indian government will abide by the promise made to the Portugal. So we have already made a promise that, that he will not be in the jail after 25 years. And that is on that promise only they have handed over the Abu Salem to the India. So this is one of the reasons. Then it further says that after the completion of 25 years of sentence and in compliance of the commitment to the courts in Portugal, because we have promised the courts in Portugal, it is required that government of India, so government of India, and now this affidavit has already been given that we have made the promise. Now this is the time to, abide by this promise. So the court says either the government of India or the union government must ask president to use its pardoning power so that he can be taken out of jail. कि भाई प्रेसिडेंट को बोला जाए और जो प्रेसिडेंट है अपनी आर्टिकल 72 के अंदर जो उनकी पावर है, आर्टिकल 72(1), उस पावर को इस्तेमाल करते हुए इनके सेंटेंस को कम्यूट किया जाए आफ्टर 25 ईयर्स, और या फिर गवर्नमेंट ऑफ इंडिया अपनी पावर का इस्तेमाल करते हुए अंडर 432 and 433 of the CRPC must release the Abu Salem. So the thing is that he must be released after 25 years. Hence, the necessary papers be forwarded within a month of period of completion of 25 years of Abu Salem. क्योंकि ये सारे जो papers होंगे when he will be released must be sent to the Portugal government that we have whatever we have promised to you, we have abided by the promise, we have completed our promise. So there is no fault on our part. We have not defaulted on our promise. So this promise must be taken care of. So the Supreme Court is talking about this promise. Next is, even if it is going to be, he is going to be released after 25 years, then also why this petition has been filed before 5 years or 6 years? If it is going to be happen in 2027, 28 or 29, then why did Supreme Court give this judgment five years before the completion of 25 years? So why this has been done, before the 25 years to the completion of his sentence? Why this judgment has been given? So this is a very important question which has been answered by the Honorable Supreme Court in this case. So let's see what the Supreme Court has said about it. Supreme Court says that we have found that it is necessary to make this time-bound decision because, after the completion of these 5 years, if then we will start thinking about it, discussing about it, there will be multiple petitions before us. One petition will come and go, and it will take a lot of time. And therefore, it may be a situation that we breach our promise, which was made to the Portugal. And it is not good for the, image of the Indian government, as well as the principle of the Committee of Courts. So one thing is that it is the image of the government of India, because we need that. We already know we need many such extraditions from different countries, because we know there are multiple economic offenders, multiple terrorists who are hiding in different countries. So this is very important for us that we must abide by the promise which we have made to some other country. Second is the principle of comity. principle of committee, or we can say principle of committee of courts. So what does it mean? It means that the orders being given by the court of some other country, with the case which was under the jurisdiction of some other country or some other court must be abide by, usko bhi hum mane aur uska jo hai सम्मान करें. We must respect the orders made by some other court in the some other country. So that's why these are a few reasons because of this we must release him on the time. We must not delay this. Okay, that's why this has been pronounced 5 years before. And now the request made by the Abu Salem, the question related to the request made by Abu Salem. Abu Salem ने क्या request किया? Requested that the years he spent in jail, the years he spent in jail when he was in Portugal, must be deducted from the 25 years which we are talking about. But the Supreme Court has not entertained this request. The Supreme Court denied, calculating this tenure in such a way. The Supreme Court has denied this. Supreme Court observed that it cannot be lost sight that when reference is made in a set off of adjustment of periods, the reference is to proceedings within the country. जब हम बात करते हैं adjustment की, when we talk about the adjustment, it can only be made adjustment of period. When we talk about the adjustment of period, it can only be made if it is about within India. If it is in India that one court has said that he must be in jail for 25 years, but he has already completed in the same case for another case 5 years or 6 years in jail, then that can be deducted from the total imprisonment. But as this case was not in India, the fake passport case was filed in the Portugal, and he was there in the jail for 3-4 years in the Portugal. So we cannot deduct that period of time. Then the court further says the mere fact that we know that the red corner notice was already issued in the 2003 and 2. Red corner notice was already issued. Red corner notice to get this person back to the country was issued, but it has no significance. It has no significance with respect to the sentence. जेल के सेंटेंस को कम या ज्यादा करने में इस दिन पे the red corner notice was issued is irrelevant and have no relevance, no significance. There is no significance कि भाई कब इशू हुआ या कब नहीं हुआ, चाहे वो 2002 में हुआ, चाहे वो 2001 में हुआ, चाहे वो 2005 में हुआ. That has no relevance or no significance in this particular case. यहाँ पे उसका कोई relevance नहीं है. Hence, if one looks from the perspective of detention of the case in India, the period commences only on his being detained at Portugal. तो कहता है कि इंडिया का जो टाइम पीरियड है, when it comes to calculating the time period, जब हम कैलकुलेट करेंगे टाइम पीरियड को, जब हम कैलकुलेट करते हैं इस टाइम पीरियड को, we will take it from the date he was taken from the Portugal. Portugal में जब हमें हैंड ओवर किया गया, that was 12th of October 2005. From that date onwards, we will calculate the further 25 years. So when the person will complete the 25 years of imprisonment, then he will be released. So this judgment says that even if somebody is a terrorist or the hardcore criminal, but the law of law of the land is above everything. And if the law says that he must be released, and if the promise been made by the Union of India or the Government of India, that must not be defaulted. And again, here it also talks about the principle of comity of courts, that if something has been decided by a court of some other country, then we also respect that also, because they have helped us over a time. अगर उन्होंने हमारी help की है उस time पे, so we must think of them also, because we need, as I told you, we need multiple such extraditions. We need more extraditions. We know that there are multiple, economic offenders. There are multiple terrorists, and we need the custody of these people in the near future. So it is important that we must abide by the promises we have made earlier to the other countries. Then only they will believe us and give these offenders, either it is economic offender or the terrorist, back to India, so that the correct justice can be delivered in India. So this is how we need to understand this particular judgments. So that's it from this particular judgment. I hope you have understood the idea behind this, the kind of sections involved, the kind of extradition process involved, and also the principle of comity and the promises being made by the Government of India to the other countries. Thank you so much. Thank you for joining. Good night. Take care. Bye bye.